Hello and welcome to the discussions on human rights. Friends, last time we have considered the aspect of human rights NGOs and its relationship with statutory bodies. And today we are going to discuss the relationship between human rights NGOs, their roles in relation to the courts. Friends, to start with, human rights are described as the rights of the people relating to life, liberty, equality and dignity, which are conferred by the Constitution of India and contained in any international covenants. The protection of human rights has been a talk of the time, and in that regard, non-governmental organizations which are formed for the protection and promotion of the human rights have become active in order to vindicate the rights of public nature. Part 3 of the Constitution of India declared a list of fundamental rights, and a person may move the Supreme Court directly for the enforcement of any right conferred by Part 3 of the Constitution. The High Courts are also given similar power to enforce fundamental rights. The traditional mode of judicial process was designed to adjudication of the disputes between private parties over properties, over contracts, other civil liabilities, property or matrimonial matters. After a matter is dealt with by a court and a decision is given, the decision is binding on the parties, and the same matter cannot be raised again before the same court or any court of concurrent jurisdiction. An appeal may, however, lie against a decision to a higher court, and a decision in the appellate court is final and cannot be reopened by the parties and their representatives in interest. This is called the principles of the res judicata. Only a person who has suffered injury or whose right is violated can approach the court, and that too within the time of limitation prescribed by the law of limitation, and not otherwise. In such a situation, in practice, a non-governmental organization can do a little to activate a court in the matters of protection and promotion of human rights in general. Although a provision exists in the Code of Civil Procedure 1908, the provision is known as relator action, and the same is laid down in section 91 of the code, where in the case of public nuisance and other wrongful acts affecting the public or likely to affect the public, a suit for declaration, injunction or for such other reliefs as may be appropriate in the circumstances of the case may be instituted by the Advocate General or with the leave of the court by 2 or more persons, even though no special damage has been caused to such person by reason of such public nuisance or other wrongful act. An NGO may at the most involved in filing a relator's suit under this section before a civil court by obtaining leave from the court to agitate the matter if arises for the benefit of the public, even though no injury is caused to it. But a recent trend is visible as if public duties are to be enforced and public interests are subserved by their enforcement, public spirited persons or human rights organizations are permitted to move the court and act in furtherance of the group interest, even though they may not be directly injured in their own positions. This trend is seen to develop by the Supreme Court in 80s, and here the role of the human rights organizations and NGOs would become significant in promoting and protecting human rights by taking recourse to the judicial process. We will discuss here the liberalization of the rule of the locus standi and also the role of the NGOs relating to enforcement of human rights by filing social action litigations. Illustrations will be made by referring to some decided cases also. So now let us come to the liberalization of the rule of the locus standi and the NGOs to espouse the public cause. The era of liberalization of the rule of locus standi can be seen in the view of Justice P. N. Bhagwati in the People's Union for Democratic Rights versus Union of India, AIR 1982, Supreme Court 1473, popularly known as Asiat Workers Case. The court laid down that any member of the public or social action group acting bona fide can invoke the jurisdiction of the high courts and the Supreme Court, seeking redressal against the violation of the legal or constitutional rights of persons who, owing to social or economic or other disability, cannot approach the court. Many human rights NGOs came up to the Supreme Court for enforcement of the invaded human rights and obtain orders to redress the grievances of the public. This will be illustrated by referring to some reported cases where human rights NGOs acted promptly, accurately, and in the interest of general public. So some illustrative cases. Common Cause versus Union of India, 1992, Volume 1, SCC, page number 707, which is popularly known as Consumer Court Case. The petitioner Common Cause is a registered society in espousing the cause of members of the public, filed the petition 2 years after the act known as Consumer Protection Act 1986 came into force, complaining that the implementation of the provision of the act was lethargic. The machinery for the redressal of the grievances of the poor consumers at the base level, that is the district forum in every district in India, had not been set up in all the districts in the country except a few. This writ petition was moved under Article 32 of the Constitution for a direction to the appropriate government for urgent implementation of the provision of the Act. The Supreme Court issued notices to the Union, the state governments, and the Union territories, requiring them to file counters indicating the Act or the actions taken for setting up district forum in each district under the Act. Reasons have been shown by filing counter affidavits, and whatever be the reasons, the fact remains that states have shown no urgency in setting up the network for protection of the consumers at the district level. The Supreme Court ordered the concerned government to be alive to its responsibility to activate the consumer forum, that is the district forum, in every district as envisaged by Section 9 of the Act. Thus, the inaction of the state governments to set up district forum under the Consumer Protection Act 1986 was unearthed by the initiative of the human rights NGO called the Common Cause. To mention another case, People's Union for Democratic Rights versus Union of India, AIR 1982, Supreme Court 1473, is a case known as Asiat Workers case. The petitioner is an organization formed for the purpose of protecting democratic rights, espoused the cause of the workmen employed in the construction work of the various projects connected with the Asian Games. The matter was brought to the attention of the Supreme Court of India by means of a letter addressed to the then Judge of the Supreme Court, Mr. Justice P.N. Bhagwati. The letter was based on a report of a team of 3 social scientists who were commissioned by the petitioner organization for the purpose of investigating and inquiring into the conditions under which the workmen employed in the various Asiat projects were working. The matter espoused by the petitioner organization was registered as a writ petition by the Supreme Court. The Asian Games takes place periodically in different parts of Asia, and the year 1982 was the turn of India to host the games. To accomplish the game festival, the government of India had to take steps to construct various structures by entrustment to the Delhi administration, the Delhi Development Authority, and the New Delhi Municipal Authority. It became the concern of the court, being apprised by the petitioner organization, to see that in future labor laws are implemented in letter and spirit, and the rights of the workmen under the law are not violated. The Supreme Court, after a thorough consideration of the matter, found out from the materials on record that the Jamadars deduct ₹1 per worker per day from their daily wage. The court directed the Delhi administration and the Delhi Development Authority to hold such inquiry, and in case of finding any worker receiving less than the minimum wage, to take necessary legal action against the contractor, whether by way of prosecution or by way of recovery of the amount of the shortfall. It was further held that thereafter, when any contract is given by the government or any governmental authority, including a public sector corporation, it should be ensured by introducing a suitable provision in the contracts that wage shall be paid by the contractors to the workmen directly without the intervention of any Jamadar or Thikadar, and that the contractors shall see that no amount by way of commission or otherwise is deducted or recovered by the Jamadars from the wage of the workmen. To mention another case is Naga People's Movement for Human Rights versus Union of India, AIR 1998, Supreme Court 431, known as the APSPA case. The petitioner is a non-governmental organization formed for the protection of the human rights, particularly for the Naga people. The matter is a writ petition challenging the constitutional validity of Armed Forces Special Power Act 1958, a central act, and another act called the Assam Disturbed Areas Act 1955, enacted by the legislature of Assam. The Armed Forces Special Power Act 1958 extends to whole of the state of Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, and Tripura. The Armed Forces Special Power Act 1958 was challenged for being given unbridled powers to the armed forces deployed in the regions, and the Supreme Court examined the matter at the initiation of the human rights NGO, that is the petitioner. Although the petitioner asserted that the act is unconstitutional, the Supreme Court, after a review of the Act and discussions in the light of the constitutional provision and precedents, held that the Parliament is competent to enact the Act. Section 3 of the Act does not confer an arbitrary power to declare an area to be a disturbed area. There should be periodic review of the declaration before the expiry of 6 months. The powers conferred upon the non-commissioned officers are not arbitrary. A person arrested and taken to the custody should be handed over to the officer in charge of the nearest police station with least possible delay, so that he can be produced before the nearest magistrate within 24 hours of such arrest, excluding the time taken for journey of such arrest to the court of magistrate. These are some of the observations of the court, but the petition was dismissed. However, this is another instance where an NGO has come forward to challenge the constitutional validity of an act for the purpose of protecting human rights. We may refer to another case also, Bandhua Mukti Morcha versus Union of India, AIR 1984, Supreme Court 802, also known as bonded labor case. The petitioner is a non-governmental organization dedicated to the cause of release of the bonded laborers in the country. The system of bonded labor has been prevalent in the various parts of the country since long prior to the attainment of political freedom, and it constituted an ugly and shameful feature of our national life. The petition was filed by the organization alleging that a large number of the laborers from Maharashtra, MP, UP, and Rajasthan were working under inhuman and intolerable conditions in stone quarries situated in Faridabad district of Haryana, and some of them were bonded laborers. At the initiation of the NGO, the Supreme Court allowed the writ petition and gave innumerable directions numbering 21 heads. Some important directions are: the government of Haryana will constitute vigilance committee in each subdivision of the district and instruct the district magistrates to take up the work of identification of bonded laborers as one of their top priorities. Periodical camps are to be held in the area to educate the bonded laborers with the assistance of the National Labour Institute. The government of Haryana shall take positive action to rehabilitate the bonded laborers within a period of 3 months. The central government will take task to ensure payment of minimum wage to the workers of the stone quarries directly. The central government will direct the inspecting officers to carry out surprise visits once a week to see that the trucks are not loaded in excess of the true measurement capacity. Further directions are also given to provide drinking water, medical aid, to handle explosive devices by expert hands, and provision of maternity benefit, report of injuries, visit of inspecting staff to find out any injury cases. The court appointed Joint Secretary, Ministry of Labour, Government of India as commissioner to carry out monitoring of the work site. Lastly, the court expressed the confidence that if the directions are carried out, it will ensure better living condition of these workmen. Well, let us conclude. The role of the human rights NGOs in relation to espousal of the public cause in the courts in India became significant when the Supreme Court of India in the 80s started entertaining public interest litigations and the resultant relaxation of the rule of locus standi. Some illustrative cases that are discussed above are not exhaustive. There are many and will be more in the future. The epistolary jurisprudence of treating letters to be writ petitions has added the use of NGOs more meaningful. There have been various involvement in NGOs in environment protection and prevention of political corruptions and crimes. The Supreme Court is also alive in response to the cry of the NGOs to protect human rights, where an organization of human rights moves the court on behalf of the class of persons who, on account of poverty or disability or socially or economically disadvantaged position, cannot approach the court for relief. Such organization can move the court by a letter addressed to a judge of the court. The idea behind is that it is not just and proper or fair to expect an NGO acting in pro bono publico to incur expense out of his pocket to pursue a cause for the mass. The scope of NGOs to make involvement in the courts to protect human rights is and will be wider and wider in future. So friends, this much for today. Have a good day.